Judgment in the appeal, Anson and the Commissioners for Her Majesty's Revenue and Customs.
Lord Reid will deliver the judgment.
UK taxpayers are generally liable to pay income tax on their income arising overseas. That income may also be taxed in the foreign country where it arises. In order to avoid the same income being taxed twice over, the UK has entered into treaties with many foreign countries under which each country agrees, when taxing income arising in the other country, to give credit for the tax already paid on it. This appeal is concerned with the application of a treaty of that kind, entered into by the UK and the USA. The appellant, Mr Anson, is a member of a Delaware limited liability company, or LLC, a type of entity which has no precise equivalent in the UK. It carries on business in the US and is treated as a partnership for US tax purposes. Mr Anson therefore pays income tax in the US on his share of the profits of the LLC. As a UK taxpayer, he is also liable to UK income tax on his US income. The question is whether he is entitled to credit for the tax already paid in the US. The Commissioners argue that he is not. They say that his income arising in the US, on which he is liable to tax in the UK, comprises the payments that he received from the LLC. They say that that is not the same as the income on which he was taxed in the US, which was his share of the profits of the LLC. This rather technical argument is based on the idea that since the LLC is an entity distinct from its members, the profits of its business must belong initially to it, rather than to the members. Mr Anson's income, so far as UK tax law is concerned, is therefore argued to be not the profits of the LLC, or a share of those profits, but a payment made to him by the LLC which is derived from the profits. This argument was rejected by the first-tier tribunal, but it succeeded on the Commissioner's appeal to the upper tribunal, and also on Mr Anson's appeal to the Court of Appeal. Mr Anson now appeals to the Supreme Court. The Supreme Court unanimously allows Mr Anson's appeal. Under the treaty, it is necessary to identify, in the first place, the income liable to tax in the UK. That is agreed to be the income arising to Mr Anson in the US. But what exactly is that income? Is Mr Anson entitled to a share of the profits of the LLC as they arise? Or does his income only arise when payments are actually made to him by the LLC? The Commissioners argue that this is a question of UK tax law, and that argument was accepted by the Court of Appeal. But it appears to this Court that Mr Anson's rights in relation to the profits of the LLC are governed by US law, and are therefore a question of fact in these proceedings. UK tax law then has to be applied to those facts. It was the responsibility of the first-tier tribunal to find the facts. It heard expert evidence about US law, and it concluded on the basis of that evidence that Mr Anson was entitled under US law to a share of the profits as they arose, prior to any payment being made to him in satisfaction of his entitlement. On the basis of that finding, Mr Anson's taxable income under UK tax law was his share of the profits. It's accepted that that was also his taxable income under US tax law. Since the same income is liable to tax in both countries, it follows that he is entitled to relief under the treaty, and this appeal is therefore allowed.